Forum video channel. Our mission is to empower citizens of India by sharing knowledge about the Constitution of India and the fundamental rights which they have been given by the Constitution of India. If you're watching us for the first time, click the subscribe button, select all. So whenever we upload a new video or we go online, you get a notification. And sharing this video with your contacts and friends would be greatly appreciated. आदाब, नमस्कार, सत श्री अकाल दोस्तों, आप सभी का स्वागत है सिटीजन जस्टिस फोरम के इस वीडियो चैनल पर। हमारा मिशन है भारतीय नागरिकों को उनके अधिकारों के बारे में जागरूक करना जो उनको हमारे भारतीय संविधान ने दिए हैं। अगर आप ये वीडियो पहली बार देख रही है तो सब्सक्राइब कीजिए, बेल आइकन को क्लिक कीजिए, सिलेक्ट ऑल कीजिए ताकि जब भी हम नए वीडियो अपलोड करते हैं या ऑनलाइन आते हैं तो आपको उसका नोटिफिकेशन मिलेगा और आप हमारे साथ में जुड़े रहेगा। आज की जो टॉपिक है वो कोऑपरेटिव हाउसिंग सोसाइटी को लेके है। हमने पिछला एक सेशन किया था जिसमें हमने एक पार्ट कवर किया था। अभी आज जो है वो सेकंड पार्ट कवर करेंगे और काफी ये जो नॉलेजेबल टॉपिक है तो शुरू से एंड तक देखिएगा। मैं आपके साथ में एक शेयर करूंगा कि जो प्रोसीजर और फॉर्म जो है वो उसकी बुक मिलती है फेडरेशन में और इसके लिए जो कोर्ट फीस जो बनी रहती है स्लैब वाइज वो भी आपको इस पन्ने पे मिलेगा। रेजोल्यूशन का भी ड्राफ्ट मिल जाएगा तो आपको काफी सारी सुविधाएं हो जाएगी। और अगर आपको कोई प्रश्न है तो आप चैट बॉक्स में डाल सकते हैं या हमारे को व्हाट्सएप में भेज सकते हैं। मैं मोहम्मद अफजल और ये इसरानी जो आज की ये टॉपिक कवर करने वाले हैं, ही इज ऑलवेज रेडी टू हेल्प। एंड नाउ मैं ज्यादा आपका टाइम नहीं लूंगा और हम चलते हैं सीधा टॉपिक पे और सीए अमित इसरानी प्लीज।
Thank you. Good evening, all. At the last session, we covered certain portions of the old number 101. Now, the new number is 154B29. We had taken the viewers through certain procedures which were to be observed by the members or by the society. And members have to follow certain procedure if they feel that the application made is wrong. So what were the safeguards they had to do was discussed, and the society felt that the section for recovery is correct and the amounts are right. What they have to do was also covered. And at that time, I had mentioned that this section 154B29 or the old 101 is a procedural section. Procedural section माना कि it's a summary hearing in which certain process has to be followed as laid down by law. उसमें discretion नहीं होता है. So both the member and the society, whoever are in the process of the application, have to ensure that the process as laid down in the section and the relevant sections are followed absolutely meticulously. थोड़ा भी deviation होगा उसमें, then one of the two parties would come out losing, not because of merits, but because the procedure was not followed as laid down by law. और law का एक standing settled position है that if a matter has to be done in a particular manner as laid down by the statute, it has to be done in that manner and no other manner. So that is the guiding principle on the recovery. Let's just go into the preamble for a short while before I get into the main details. All members who are of a society have to pay their maintenance, they have to pay the repair charges, they have to pay the dues, and all the charges as permitted in the bylaw, not necessarily as decided by the managing committee. So we have certain issues where managing committee comes out with certain charges and starts debiting. Once you have that issue, the member does not pay, and then they move into 101 or 154B29 recovery. And in the course of the recovery, if the member feels कि justified नहीं है, then the ideal thing for him to do is to get into a dispute situation by moving the appropriate forum or court कि ये dispute है हमारा, so recovery में नहीं जाने का. But if that is not done and the recovery procedure starts, then it is assumed that the amount that is written in the statement submitted to the member is correct, and registrar does not go into the merits, except if you raise the point of merits which are very serious and which can be shown कि भाई जो हमको चार्ज किया है, हमने कंप्लेन किया है, कंप्लेन सुना नहीं है, ने आपको भी complaint किया है for wrong billing, and those have not been heard by the registrar, then registrar has to clear those applications before he will clear the application for the recovery certificate. Now, the fundamental of 154B29 is issue of recovery certificate, which means it is pre-decided that you are owing the money, member is owing the money, and registrar only hears the recovery certificate to be issued. तो वो ध्यान में रखना है, तो उसमें काफी जाते हैं, मेरिट्स में टाइम जाता है, और उसके लिए 2 महीना प्रिस्क्राइब किया है, within which registrar has to issue the recovery certificate. And all the areas which needs to be looked in, I have covered in my previous discussion in the channel. Today I will go into the rules part of it. Now, in any act, you are having multiple documents which need to be looked at. One is the act, which is the principle on which the law is based. Then we have the rules, which are like the wheels of the law, which tell you how to implement that particular act. Then you have the bylaws and you have the government GRs, which support the entire exercise. And because it is a procedural situation, we have a rule which is to be read with the section. So section 154B29 में rule आता है, rule 86, which tells you about the fee. Rule 86A, which gives you the procedure of how the application society has to make. And if the application is not made in line with that, then the argument will be that it's not as per procedure, and the argument can be done by the member. Then we have 186F, which is the format in which the recovery certificate has to be issued. And there's a slight confusion sometimes whether 86 has been notified so far as 154B29 is concerned. So we have to make sure that if the certificate is issued under 86F, then automatically all other A, B, C, D are also to be followed. So that would be the argument which we would have to take. अब उसके साथ में we have a certain section which is 156, 155 and rule 107 and rule 107. So if we are having rule 107 is where I will now be talking. Rule 107 comes in the play moment the recovery certificate is issued by the registrar. Then society has to make an application to the recovery officer that he has to start executing the recovery process and executing the certificate. So recovery process may he has to follow the rules as laid down. So rule 107 of the Cooperative Society Rules 1961 is what has to be followed, and if that process is not followed, then that gives an element where the recovery certificate can be cancelled, or we can move the court to have it cancelled. So for society, it is very important that they follow the procedure, and for the member who is affected, it is very important to ensure that if it is not followed, that becomes an escape route for the member to file an application saying procedure is not followed, therefore recovery cannot take place. Now, because this is a procedural rule, you take your permission and liberty to read the rules because they have to be followed as they are written. So I will have to read them and I will not be talking ad verbatim. But at every stage, when I read out 4 or 5 rules, then take a pause and explain the significance of those 5 or 6 rules, and then get on to subsequent part of the 107. Well, 107 has many sub-clauses, and each clause has its own complication, own impact, and importance. So 107 rule क्या बोलता है? Procedure for attachment and sale of property. Now, before he executes the recovery certificate, there has to be an attachment, and there has to be a procedure, and the property has to be sold. So when you use the word property, it does not necessarily mean your flat. Property means also movable property. So if you are in a society, recovery certificate issued for a particular value, the recovery officer has to come and first take care of the movable and say हम पहला तुम्हारा movable बेचेगा, उसके बाद में flat को आएगा. So if the amount outstanding is, for example, 2 lakhs, he doesn't have to attach a whole flat of 2 crore and 3 crore and 5 crore. So he will first come and attack your motor car, or he will attach your table, chairs, or whatever it is. He can also take your negotiable instruments. For example, if you have a check lying payable to you in your house, he can attach that check as well. and say now this check will become payable to society, not to your account. And I'm attaching that and I will get it transferred and pay the society debt. So there are various functions and various methodologies which are in 107. So detailed understanding of 107 is very, very important. The first point is a creditor holding a decree, that means the society holding a decree requiring provision of section 157 to be applied or society to which it applies. उसका पहले definition दिया हुआ है A, B, C, D, E. So I will go to CHSL E, an amount due under a certificate granted by the registrar under section 97, 98 or 154 B29 or the old 101 if it's an old matter still continuing. Under subsection 102 of section 101 or other subsection of 137 together with interest, or if any amount due, such amount with cost and the procedure. उसमें cost भी आता है. In other matters, when the matter goes to court or registrar's office, cost नहीं आता है. So if you go for application of membership or you go for repairs, उसमें registrar cannot award cost. But under this particular section, the fees paid and the cost incurred can also be part of the claim together with the interest. And normally the interest calculation is done for the statement given by the society till the time the recovery is made. That means even while the hearing is on, the interest is being charged. Even when it goes into appeal or revision, the interest continues to be charged. Even if there is a stay, the interest continues to be calculated. If the order comes against, then all the interest has to be paid. And at the end of the day, till the money comes to the society, even after all the orders are passed and the delay is there in payment or part payment is made, then interest on the remaining part keeps on accumulating. So there also I had advised last time that when you make a payment, you make a specific payment of the principal amount and write a check, say this is the principal amount I am paying, so that no interest will be charged. So that is permitted under certain sections of the contract, which you'll have to work out with your legal team. अभी हम जाते हैं थोड़ा आगे लेके कि authorized officer जो आता है or the person who comes as the recovery officer, what is he supposed to do? First is the application has to be made by the society. The society does not make an application to the recovery officer, he cannot initiate the recovery process. The society has to make a recovery process by making an application to the recovery officer, whose office is normally in the federation office, because recovery comes under the jurisdiction of the federation. And then application is made, please go ahead and follow the procedure and get on with recovering the money for the society. The second part of this particular section says, every such application shall be made in a form specified by the registrar and be signed by the applicant. So the format is part of the procedure. A simple letter to the authorized officer saying, please come and recover, would not be a good application. So in law, a format has been made which has to give a lot of details, and all those details have to be filled. And I will read the section again. It says, every such application shall be made by the applicant in a specified form and shall be signed by the applicant, shall be accompanied by the deposit of such amount as may be specified by the registrar to cover the cost of the process. So when you go for executing the recovery, there is the cost. So that amount is specified in the law, and based on that, that amount is made payable, and then you get on to giving an application in a specified format. Under such scales, the fee for issuing a notice shall not exceed rupees so and so. उसका पूरा procedure दिया है, which I will not go into detail. 3 says on receipt of an application or when the registrar is proceeding under Rule 84, the recovery officer shall have to verify the correctness and genuineness of the particulars in the application with the record. That means if they write in the application that flat number so and so belongs to so and so, then the recovery officer has to first verify. वो सचमुच उसके नाम पर flat है. He has to go to the society, verify the records, and then only he can proceed. So he should not come to a situation where later on it is found कि उसने flat बेच दिया. Recovery जब situation चालू था, so the defaulter has sold the flat or created third-party rights or taken a bank loan and created a third-party liability. All those things have to be cleared off. also to ensure that encumbrance free. So the authorized officer has to go and verify the correctness, genuineness of the particulars in the application and prepare a demand notice in writing in duplicate in a specific form and give it to the registrar, giving the name of the defaulter, amount due, etc. तो पूरा डिटेल्स के साथ प्रोसेस है. अगर वो प्रोसेस नहीं फॉलो हुआ, then again it will be a default in the process. The recovery can go haywire. Then we have the next procedure, which is unless the applicant has expressed a desire that the proceeding should be taken in a particular order as laid down, execution shall be taken in a manner which is prescribed. तो एप्लीकेशन में भी उसको दिखाना पड़ता है कि हमको पहले क्या रिकवर करना है, इमूवेबल करना है, मूवेबल करना है, तुम्हारा कोई राइट्स है, तुम्हारा कोई रिक्वायरमेंट है, कोई ड्यूज है, वो सब देखने के बाद then only he will applicant has to desire. So the word is unless the applicant has expressed a desire. Sometimes the applicant will go and say, you go and get me the flat. The society में हमको फ्लैट मांगता है, हमको उसका गाड़ी बंगला नहीं मांगता है, हमको उसका फर्नीचर नहीं मांगता, अपने को फ्लैट मांगता है. So then also there is a procedure that has to be followed. If the proceedings have to go for movable property or immovable property, the amount cannot exceed the amount which is in the recovery certificate, plus the interest that is due up to the point of recovery. So if we get on to say ki there is a amount which is 2 lakhs, then society says I want the whole flat worth 5 crore. He cannot do that. He has to go and only put recovery for 2 lakhs. So he will say, no, I will not do that. There are movables which I have seen. He's got a car which is worth 5 lakhs. पहले मैं वो ले लूंगा, तुम्हारा requirement discharge हो गया, so I don't have to attach the flat. So those are areas where the member who is being charged or the society who is making the application should make sure that the demand is genuine, correct, equitable, also in keeping with the moral and the principle of natural justice. Not merely saying, अरे अपने का उसका गाड़ी दे दो, उसका घर दे दो, वैसा, because I don't like the face of the member, he's been too critical, now we'll teach him a lesson. Those kind of stories should not come in. Then we have section 1075, which says recovery officer shall, after giving previous notice to the applicant, proceed to the place where the defaulter resides, which means that if the defaulter is not residing in the flat, he cannot just walk into the flat because notice has to be given to the defaulter. So he has to find out where the defaulter is residing and then go to the defaulter and then issue the notice and then get the property distrained. Distrained is a word that is used in this particular section, which means to confiscate. So he has to go and confiscate the movable property and take it under his charge. So you will find the word distraint is used many times in Rule 107. And together with the expenses, he has to then make a distress. उसको कहते हैं to make a distress. That means make an attempt to confiscate the property. And when he makes a distress call, it is called distrained. So the word distrained comes from distress. And then immediately deliver to the defaulter a list of inventory of the property which he wants to sell. So he will go to the flat, look at the property, take photographs, get a valuation done. Say, तुम्हारा 2 लाख due है, मैं तुम्हारा TV बेच दूंगा, I will take away this, I will. He has to make a list, give it to the person. He just cannot walk in and say, well, I'm selling everything. The value that he is going to get should not exceed the amount that is there. Now, the notice किसको देना है? Notice has to be given to the male member, not to the female member. So if you have two husband-wife team, service on female question mark होता है, because rule says recovery officer shall serve the demand notice on some adult male member of the family or on the authorized agent. So if he serves it to the child or to the servant who is not a male member of the family, then that service is not as per law. So I keep on repeating again and again, both the society and the member concerned, please read 107 very, very carefully, take legal advice, take legal interpretation, because in this case, a lot of things depend on the interpretation of Rule 107. It is not a clean walk-in. It is just not a clean walk-in. And if the society makes a mistake, certificate will go through the window. If a member makes a mistake, his property will get attached, and once it is attached, then very, very difficult to reverse. Recovery officer shall serve a demand note to some adult male member of his family or to his authorized agent, or when such service cannot be effected, shall effect a copy of the demand notice on some conspicuous part of his residence. Conspicuous part, the size of the notice should be as per law. It should be put on the door, not on the side or behind the window or on the back door, where it is noticed by whoever comes in. If there are two entrances, put it on both the entrances. Then take a photograph. Get a witness that this has been served, so that the process is completely foolproof. And then he shall also fix the list of property attached on the usual place of residence of the defaulter. Now, usual place of residence also, जो लिखा है इसमें, you will have to consult your lawyer at that time, who will help you and assist you. So I am giving guidelines based on the law. I am not giving an opinion. Please understand. So members and society, please consult your legal advisor. Make sure that whatever words are used are correctly defined and opined by the lawyer, who will then give you on your case as a unique case. Each case is unique, making a very general run through the system. I'm not going into unique cases. So you will have to consult a legal person who will then give you the definition का मतलब क्या निकलता है, कोर्ट की जजमेंट्स में क्या मतलब है, ऐसे केसेस में क्या precedents हैं, and based on that you will move forward. After the distress is given, the authorized officer or recovery officer may arrange. Now it says may arrange, not shall arrange. That means there is a room you can plead with him, and you can say, "Baba, थोड़ा रुक जाओ, मैं दे रहा हूँ पैसा, घर मत ले लो, मेरे को दूसरा घर नहीं है." So there is a remedy which is available, because after all, cooperative law is humanitarian law for residents of people. So they have worded in such a way, may arrange for the custody of the property attached with the applicant or otherwise. And if the authorized officer requires the applicant to undertake the company custody of the property, so which means that when he goes to the house of the member, he can take possession and give it to society to hold in custody. Society cannot use those property. If a TV is collected, they cannot use the TV, because if they use it, then they contravene the law. So they are holding the property in trust. First, the member can go and make the payment. So till it is not sold, the member can say, "Okay, I'm discharging my liability," or he may get a stay order from another court, whatever may happen. So the property is only in the custody of the applicant, because authorized officer cannot carry it to his own house. So it has to be kept in the custody of the applicant, which is the society. Property, undertake the custody of the property, he shall be bound to do so, and any loss occurred or negligence, due to negligence, then the society is liable to make good those losses. For example, if they leave the TV in the house society office and it falls down and is broken due to negligence or otherwise as defined, then the society will be liable to make good back. May, at the instance of the defaulter or any person claiming interest in such property, leave it in the village or place. The whole definition is given, which once you read, you will go. So I will not go into details, otherwise I will not be able to complete all the points. So I will run through and leave certain reading material to the clients who are watching, or the members who are watching this. Other thing is that the distress shall be made after sunrise and before sunrise. Now, after sunrise does not mean morning. After sunrise is the sunrise hour as per the methodology. So if he comes at 7 o'clock and then the sunrise is 7:05, then you have an issue you can contest. So he has to make sure that he takes the timing, gets the sunrise. He cannot come at midnight. And same thing, sunset. So distress shall be made after sunrise and before sunset, and not any other time. It's specifically stated, not any other time. So when he comes to make the distress call, please ensure that he records the time, he puts the time, then you go to the meteorological department and say, what is the sunrise on that day? If there's a variation, then the member has a chance to say he came not in line with the rule, and therefore the distress is not valid in law. Then the second portion D, it says distress shall not be excessive. That is to say, the property distraint shall as nearly as possible be proportionate to the sum due by the defaulter together with the interest and all expenses incidental to the detention and sale. तो जो भी वैल्यू होता है उसका सेल कॉस्ट कितना है उसको कंप्यूट करना पड़ेगा. Then we will have a situation that he cannot take more than the amount due. If he takes more than amount due, then legal process of taking a property not liable, जो भी sections आते हैं general law में वो lawyers can apply that and come out. Now there is one more issue which is very important, that when the officer comes to restrain the property, he cannot restrain the property or the room where a woman member is residing. A woman can never be dehoused, please understand, under this section. So if there is a room where a lady is having her bedroom, that bedroom cannot be attached. Zanana jisko bolte hain, that property of Zanana cannot be attached. She cannot be removed from the house and put on the street. I will read that section when I come to it, but I connect it with the timing. So timing and the location I have. Then the recovery officer shall not work on the bullocks or the cattle and use of goods or effects restrained, which means that whatever items are taken in custody, the recovery officer or the society applicant cannot use them. They cannot send the TV to their house and say, जब तक बेचा नहीं है मैं देखूंगा अपने घर में. It shall be lawful for the recovery officer to force open. उसको force open करने का भी power है. To force open any stable, cow house, go down, outhouse, or other building, and he may also enter any dwelling house, the outer door of which may be open. So if the outer door is not open, then he will need some other order to follow. I'll read this again. It shall be lawful for the recovery officer to force open any stable, cow house, granary, go down, outhouse, or other building, and he may also enter any dwelling house, the outer door of which may be open, and may break open a door of any room in such a dwelling house for the purpose of attaching property belonging to the defaulter and lodged therein, provided always that it shall not be lawful for the recovery officer to break open or enter the apartment of such dwelling house appropriated for the zanana or residence of the woman, except as provided. So this becomes a very, very important clause where many a times they come in with a group of people, they come in with the committee members, they all enter the house, they bring their cameras, they want to record. Those things are not permitted because that goes on the privacy rights. So only recovery officer, it does not say in the rules, recovery officer together with the applicant and the team of the committee member together to be photographed. वैसा नहीं है. The recovery officer has the power, which is only his exclusive power, and it cannot be delegated to the applicant. He cannot come in, because it is noticed quite a few times. Whole group of people walk in and enter the house. ये भी हमारा हो गया, ये भी हमारा हो गया, तुमने सोसाइटी का पैसा नहीं भरा, टीवी लेके जाओ, ये करो. No committee member, no chairman, no secretary, no treasurer have any power to enter the house on this condition. Only recovery officer has the power. So that is an angle also which one has to be extra careful. And then the issue is about zanana. Now, if you have a house, for example, where there are only ladies, then you have to make sure the society has to get the appropriate orders to enter. And same way, the member also can stop them and say, sorry, recovery officer, you cannot come in because we are only ladies in the house and you cannot come and get a court order. They would be reasonably okay to restrain the officer from entering. The next thing is that where the recovery officer may have reason to believe that the property of a defaulter or the outer door of which may be shut and apartment is appropriated to a woman because of custom or usage, the recovery officer has to report this to the officer in charge of the police station. He cannot enter on his own. then he has to follow the whole process of getting orders and then come back again, following procedures. Now, on this issue, I would request Advocate Bhimani, because there are a lot of legal issues, so probably he can throw in some light to the viewers.
We do it.
तो ये एक issue है जहाँ थोड़ा उस पे
Whether the recovery officer may have reason to believe that the property of a defaulter is lodged within the dwelling house, the outer door of which may be shut, or within any apartments appropriated to women which may custom or usage are considered private. The recovery officer shall report the fact to the officer in charge to the nearest police station. I'll share an incident which happened with me. I was fighting a DV case, and the mother-in-law filed a case against the daughter-in-law in the Senior Citizen Act, and she was given an order that the daughter-in-law should be evicted. Now the police comes, they enter into the bedroom of the daughter-in-law and take her to the police station and make her write an undertaking that before 6th or 5th May, if she doesn't obtain any stay order, the police will throw her outside the house. So I was appearing on behalf of that daughter-in-law. It is not related to the cooperative society, but it is related to the powers of ladies. So you will come to understand. So I was in front of one of the esteemed judges. Then when I narrated the story and I said that this is the letter which I have to even in duress to the police station that by Monday or 5th or 6th May, if I don't obtain an order, then they will come and throw me out, and a 6-year daughter will be on the roads. So then the judge asked me, can the lady identify who is the policeman? I said, yes, definitely. Can she give an affidavit? I said, yes, she will give the affidavit in the writing that this and this incident happened. Then he told that I will write to the commissioner that how without a lady officer, they have the right to enter into the bedroom. So this covers all, whether it is for the recovery also or for the eviction also. Then she gave the affidavit, and then she got a stay. Stay is still working. She's not thrown out of the house. But mother-in-law had one more house. She shifted there and she's living peacefully. So these are the rights which are given to you. After sunset or before sunset, no police officer or a recovery agent, whether it is of the cooperative housing society or whether it is of a bank or of a credit card, can enter or knock the door. So that rights you have, which you have to understand. So this is a fundamental right, and right to privacy. Nobody can just barge into your bedroom and start recording. So this, if it happens, you have the right to complain against them, and the courts are really very appreciative. If you approach with this type of case, they immediately act and promptly they act. Anything else you want to highlight?
it does not mean that you use it as an excuse not to pay your dues.
Yeah, that should not happen. See, if you are living in a society and when we are enjoying the leave, the common area, the swimming pool, the garden, the security and everything is there, the housekeeping staff is there. So I know the times are not same and there are tough times. So there are some businesses who have suffered losses due to the COVID or due to the upcoming of the metro. I don't want to name one of my friend whose shop is been shut for the last 2 years because the metro work is going on. He himself cannot enter. He has to enter from the back door. So what do you expect? How he's going to do the business? So there you have to take some human approach, but whatever the legal debt is debt. So you have to come out with a solution, but with a human heart and with a human touch.
I'll continue reading. The recovery officer may also, in the presence of the police officer, after due notice given to the removal of women within the zanana, and after furnishing means for their removal in a suitable manner. So here we have an issue of dignity coming in. and if they be a woman of rank, who according to custom or usage cannot appear in public, enter the Zanana apartments for the purpose of distraining the defaulter's property, if any deposited therein, if found, shall be immediately removed from the apartment, and they shall be free to the former occupants. That means when such situation arise, they have to handle carefully, and those could be caution which both society has to take, the applicant has to take, recovery officer has to take. Recovery officer shall on the day previous to and on the day of sale, suppose he has taken the item and restrained the movable property, then day before the sale, cause the proclamation of time and place and intention of sale to be made. That means he just cannot walk in at 10 o'clock and start sale. He has to give a day before notice, make a proclamation, and proclamation कैसे करना है वो भी बताया गया है law में. Proclamation of time and place intended for sale to be made by beat of drum in the village in which the defaulter resides, and in such other place or places as the recovery officer may consider necessary to give due publicity to the sale. Which means that if he does not give publicity, just walks in with four of his friends and starts to sell the property, that sale is bad and wrong. One day before, he has to come, beat the drum, inform the fellows that look, and he has to inform at his normal place of residence and where the property is located. There are two things here. And then no sale shall take place until after expiration of 15 days from which the notice has been given. So one day before the notice, date of sale, he has to come and make the noise and then give 15 days notice and then start the sale. Which means that the member, if he wishes to make the payment or recovery karna, kya karna, it can happen. Provided further that where the property seized is subject to decay. Now, if it is a perishable commodity which has been seized, then there are procedures listed under which it has to be done. So all the procedures are there, which I will not go into detail, but every item has a procedure. Every action has a procedure. Every procedure has a sub-procedure. So both the society, the applicant, recovery officer should go through the 107, go through the precedents and get a lawyer who will advise you, because these are extremely technical issues. Please do not try and handle it yourself, because you will get caught. You will not understand that there may be some precedents, there may be some rulings, as Advocate Sulaiman talked about certain orders that they got, which are not directly related but incidental to or have an impact on the action here. So an advocate who is placed towards with you would be the best one to protect the interest of the society or protects the interest of the member. Further, it says that where the proceeds from sale exceeds the amount due. Now, you may have a situation where the amount due is 2 lakhs, but he goes and makes a sale of 5 lakhs. Is that correct? Answer is no. So where the proceeds of the sale of property exceeds the amount due from the debtor, the excess amount, after deducting the interest and expenses, will be paid back to the defaulter. So if I'm defaulting 2 lakhs together with expenses, interest, cost, and he sells my TV where he recovers 4 lakhs, because there's only one item I have, then the remaining money has to be paid to the defaulter. He cannot confiscate that money, cannot pay that to the society. His job is to pay only that much amount to the society as per the recovery certificate and as per the demand note given. Now, these things are very, very important. They are very technical, and you have to follow that. Everybody has to follow that properly. Nahi follow kiya, then the whole exercise falls. Where prior to the day fixed for the sale, the defaulter or any person acting on his behalf or anyone interested in claim pays the full amount, including the interest and other charges, then the recovery officers cancel the attachment, release the property forthwith. So if the amount is 2 lakhs and all the procedure is followed, and at the time the person who wants to buy walks in with the money, the defaulter says, I'm paying the money, I'm discharging the debt, then the sale cannot happen. Even though it is announced, everybody is there. He has to receive that money, discharge the debt forthwith. Attachment release order has to be made. He can't say, I will come back and give the release order tomorrow. Can't say that. So it has to be discharged forthwith. And then the movable property is exempt from attachment. Now we have cases where there are some movable properties which cannot be attached. For example, Sridan of a woman can never be attached. Similarly, there is other item and a section 60 in the Cooperative Society Act lays down the list of items which can never be attached. The word says the movable property is exempted from attachment. That means they are exempted and they cannot be touched. And there's no discretion on that. They are all laid down in law. By the provision section 60 of the Code of Civil Procedure. If you look at the CRPC, the Code 60, probably Advocate Bhimani will throw some more light on. And we can then talk about going forward. This one. Code of Civil Procedure.
Where the movable property is exempted from attachment by the provision of section 60 of the Code of Civil Procedure 99 shall not be liable to attachment or sale under these rules. See, now there is no need, if my flat is costing around say 3 crore or 4 crore rupees, and my dues to the society is hardly 1 lakh or 2 lakh or 3 lakh rupees, so they cannot come and attach my property and sell it, right? But whatever the movable items are there, or they can seize my bank account and recover the money from this bank account. So for 3 lakh rupees, they cannot attach a property of 3 crore or 4 crore. They have other venues. They can attach my bank account and they can recover the money from that. Yeah. Some items are exempted. The following property is liable to attachment and sale in execution of the decree, namely land, houses, or other buildings, goods, money, bank notes, checks, bills of exchange, hundies, promissory notes, government securities, bonds, or other securities for money, debt, shares in a corporation, and save as hereinafter mentioned, all the sellable property, movable or immovable, belonging to the judgment debtor or over which or the profits of which he has a disposing power which he may exercise for his own benefit, whether the same be held in the name of the judgment debtor or by any other person in the trust for him or on his behalf, provided that the following particulars shall not be liable to such attachment or sale, namely the necessary wearing apparel, cooking vessels, beds, and beddings of the judgment debtor, his wife and children, and such personal ornaments as is accordance with the religious usage cannot be parted with by any woman. Now, see, there the law is there, but they have a human touch also. Like if it is my personal belonging, right, like my bed or cooking, my vessels and all. So the code or the law doesn't want you to know should not take care of your daily needs. So whatever your daily needs are, that cannot be sold. And especially now, if it is comes to the religion or if it comes to the women and children, so their rights has to be protected. They cannot just take away. Then it comes the tools of artisans. Like suppose if I'm artist and I'm painting something or I'm making something, and this is my livelihood.
So you're a carpenter with your.
Or I'm carpenter or whatever it is. So they cannot take away my tools because they are my butter, bread butter. So they cannot take away my livelihood. So I have to live, I have to survive, I have to work. So these are all things are there. So what I will do is in the end we'll make an scan copy of this, make a PDF, make a link, and we'll attach to the description box late in the evening or tomorrow morning, and you can click it and you can print and take a hard copy of it. So
the summary or the gist of the discussion is that it might appear that this section is very hard, but all the laws are made with a human heart. Because the people making the laws are human beings, and always certain considerations are given, so that it should not lead the person into penury, and we should not become that you starve to death.
Yeah.
So वो नहीं आता है, and it's a balanced law. Which again comes back to the first statement that we made, that please pay your maintenance, or if you have a dispute, go to the court, create a dispute, because if a dispute is created, then section 154b 29 or 101 would not come into play. Then the court has to decide whether amount is payable or not. If that is not done, then you fall into the section Procedure is summary. Amount due hai, bharna hai, nahi bhara, recovery officer aayega. He will follow all these procedures. Then you will start fighting, but it will be of no use because recovery certificate cannot be challenged except on certain conditions, which we will cover in part 3 when we go there because it's the longest section, so may require a part 3 also. Uh, where the property concerned is attached consists of shares, interest of the defaulter, movable property belonging to him, and other co-owners, etc. And then we come down to provided there where such property is in the custody of a court or recovery officer of another district. So he may have no property here, it may be another district. The question of title of property may not be clear, or there are other issues, or there may be joint ownership. Those are also taken care of in the rules, how they are to be treated. And they have to be determined by such court of recovery officer. So either recovery officer will determine, or you have to go to court ki bhai isme joint hai, we cannot take away. So it will lead to a lengthy recovery process, lengthy litigation. So advice always is that please sit down, sort it out, sit in the general body, sort it out, sit with the auditors, sort it out. Because now in the new approval, new section amendment, they have made it very clear that overdue debts have to be examined and verified by the auditors under section 81. So a member who has a due should apply to the auditor to say, look, please verify and tell me if it is due. That means apart from the general body or apart from the managing committee deciding, independent body of the auditor can decide. And if they are not happy with it, they can go for re-audit and say re-audit and tell us or do a test audit on my claim. And registrar will give a order. There may be some cost to it, which will be much lower than the entire process which we are taking through the recovery. So these are remedies left to people who feel they are wrong and get it corrected. And if society feels they are right, then society will proceed because society's duty is to collect the money. But the object clause of the bylaws, to form the society, there is an object clause in which the collection of the money and day-to-day doing, maintaining the building is a duty cast upon the managing committee. So they have no choice but to go ahead and collect. And here it is also very important to understand that in 2019, defaulter has been defined. And as per that, society should go and start collecting immediately. They don't have to wait for 4 years or 5 years. As soon as this financial year is over, the default is there, they should start sending the notice, start collecting and go into process. Because please remember that society is not a bank. They don't give out loans. They don't have money lending license to collect interest. Interest is a penalty. And once the penalty is there, then you have to go and recover it. You can't allow the penalty to continue. ऐसे हम तो रिकवर में जाएगा नहीं, वो भरेगा नहीं, हम 15 साल इंटरेस्ट चार्ज करते रहेंगे, and then the amount that is due on a 200 rupee penalty, amount due penalty comes to 5 lakhs. Now those are issues which again come into litigation and will create problems. So advice given by any consultant or advisor to society is moment it is becomes a default, after the due date 90 days and thereafter notice of 90 days with the 3 notices, please proceed and start the collection process. Within 2 months you get an order, collect the money and move on with a fresh deal. Do not allow, otherwise law of limitation will also come in and society will lose out in collection. The downfall of that is if society fails to collect and the order of 101 or 154B29 gets rejected and the member who is a defaulter is said you are not a defaulter, then the managing committee would become liable to make good that money from their own pocket. So there is a problem there. So please, managing committee members or the other members or the general body should be awake that there are certain things to be done in a particular manner. Don't allow default to continue. Don't allow interest to accumulate. Don't get into a situation where on a matter which I'm also handling one case where the default is 8 lakhs and the interest is 82 lakhs and the application has been made for 1 CR. For last 20 years, society has not collected. Then we have the issue of how do you appropriate, which I have dealt with earlier. That appropriation has to be done based on how the member who makes the payment decides. So if he says, I want the principal to be paid, society says, no, I will take the interest first. It is not permitted. The payer decides how he wants to discharge his liability and then carries on so that we can have a clean situation. So these are complexities which people have to understand, viewers have to understand, members have to understand. Because the idea of living in a building is not to have a quarrel or a fight. The idea is to resolve the problem at the first available opportunity so that peace prevails in the society. Committee is not burdened unnecessarily, and we get on. I other items to cover also, but that will take another 1 hour. So, with the permission of
We can do part
we
three.
can do part three, as I mentioned earlier. The part
Yes,
three maybe
because it's a
today.
lengthy this thing, and we have many questions on the chat also. One is Madam Dikona. Okay, he is a secretary from Samrat Society, Mahim. Then we have other property. What happens to the recovered movable property? See, there is no recovered movable property. The property is attached and then it is auctioned to recover the money. So it is being sold in the market, and then whatever the difference is there, if they suppose if the recovery is of 50 lakhs and the property is sold for 75 lakhs, that 25 lakhs will go to the owner of that property. So society is not going to benefit anything. They are only limited to their whatever the deferred amount is there. Then my question: if the society has not proceeded with the recovery or sorted the dispute since 2018 to 2019, can now be recovered? Yes, within 3 years it can be recovered. But why you want the society to give you a notice? So it is your society, it is your managing committee. Sit with them. What is the difference? Seek your difference, sort out the difference, and start living peacefully, and you'll have a good time with your family also.
Here I may want to just intervene.
Yeah.
Except if you find the bill is wrong, then the process is to approach the registrar by saying wrong billing, not as per provision of the bylaw. And have a hearing, registrar will decide right billing or wrong billing and correct the charge.
Uday Shankar, Ameet, a good topic for educating the CHS members. Now, Noha Matthew, second question: if bills are not issued, can the society claim for maintenance? And if the member wishes to pay principal amount and not pay the interest, no. See, the managing committee does not have any right to waive off anybody's interest. If it is that, you have to make an application and the general body may decide whether to.
There is a miscommunication.
Yeah,
I understand the question differently.
yeah.
If a member wants to pay the principal, he can say I'm paying the principal. He's not asking for a refund or rebate of the interest. Interest can continue and be recovered through the recovery process. The society can move on and say, I'm filing a recovery for the balance amount of dues. That is why if you look in the recovery one, it says amount due or service charge or maintenance or interest. वैसा उसमें दिया है.
Usually, uh, there is always many cases where the member wants to waive the interest part, only pay the interest.
He's not waiving. He's paying what he wishes to pay.
But he doesn't want to pay the interest
It
part.
can be claimed through 101 or through.
And there was one more question: whether the defaulters list can be repeated on the building's notice board.
It can be, you just mentioned flat number so and so, the default is so and so. It can be posted in the notice board, it can be posted in the.
Without the name.
Without the name. You just mentioned flat number so and so, the amount due is so and so. Now, in absence of OC or CC, see, OC and CC both are different things. CC is when you start the construction, that is called the commencement certificate. Completion certificate. That is BCC, the building completion certificate. Now, the OC and conveyance members will be charged for property tax. If you see the High Court judgment, it says there is a gray area that if you are occupying the flat you are enjoying, you are liable to pay the property tax. But as per MOFA, then you have to go to the court, and I will prefer that you go to the consumer court that there is a deficiency of service from the builder and there is what you call unfair trade practice by the builder. Under that, you approach the consumer court and you recover. But here you have to pay, and then you can quote the MOFA section also while going to the consumer court. You cannot say that I am not paying, but because if you are staying there, if you don't do, the BMC is certainly going to issue a notice under 203, then 209, and they will attach your property. So you have to take a professional advice who is well versed with this type of laws. Vimal Bhimani, sir, part one link. Okay, we'll put the part one link also. Whether you are still watching, PDF, good idea, sir. Azad Popote, can auditor be questioned about the dues in the audited balance sheet approved by the general body? See, if you have something that when the auditor has missed out, and if you come with an evidence that this is not the way, and your chartered accountants there to explain that it should not have been done it, then if it is acceptable, we can accept
There
it.
is one more important information I've shared before. I'll repeat it again. The accounts are to be kept open for inspection before sending to the auditors under Rule 61. And for 15 days, members can go and see the accounts. If they find that in the accounts the figures are wrong, then they have to write to the society. If the society does not correct it, they have to write to the auditor prior to the audit. Post the audit report says, as per information given, I'm passing this certificate. It becomes very difficult for the auditor to change his report. So if he does not get it immediately before he signs the report, then he is put in a very difficult situation.
Normally,
And there is a provision in law that the auditor has to investigate the overdue. Section 81 में provision है, audit report shall contain investigation of the overdue and verification of the overdue accounts. So on that condition, he will write to the member will write to the auditor and say these figures are not correct, and based on section 81, section subsection so and so, you have to do. Please let me know when you can sit with me and do an investigation into my account. If the auditor refuses to do it, then he will be guilty of malpractice. So he has to do it. And then if he finds, this is very important, if he then finds that the society has put wrong items, then in the same section 81, it says auditor report shall contain a report on the working of the managing committee or subcommittee, and if any irregularity is found, then he shall make a report to the registrar. So if the auditor finds that they have charged penalty which is wrong, if he has done this which is wrong, he has to make a report to the registrar and then put it in O report, which goes to the registrar and the general body, and then registrar will take a call how to do, what not to do. So please understand the rules are there, laws are there. If you understand the rules and law, which we have been trying to talk to people in our various courses, and this item also has been discussed in one of the previous
meeting.
So I'm happy that people are now asking questions, and we'll keep on giving you links of what we have covered, or have a summary discussion regularly every 3-4 months, where we can summarize all so that you get it on a platter. And we spoon feed all our viewers in the way that is easy to understand to reduce the dispute. That's the main part.
Yeah. So now Mr. Rajesh Saluja is also a chartered accountant. What is the meaning of persistent defaulter? Persistent defaulter or habitual defaulter is that right from the beginning or for the last 5 years or for the last 10 years or for the n number of years, he is not paying the society, becomes a persistent or habitual defaulter. Now, in this case, because I have gone through his case, now similarly, one more case has come to me. The interest to be charged 21% was passed 30 or 35 years back in the first term of the managing committee. Now they are not able to locate that resolution because there is a heap of documents, and for the last 35 years. Now what happens in that case when the society is not able to find out a resolution where it was passed? There are two scenarios. One is the resolution is passed, but the society is not able to find it. And in the one scenario, the society has not passed the resolution that the defaulting member should be passed, charge 21% of the interest. What happens in that case?
Take the second question first.
Yeah.
Okay, the easier one. What the bylaw says is interest shall be charged passed by general body not exceeding 21%. There are two interpretations given by various advisors. One says because the word 21 is there, so that means if you don't reduce it lower than that, 21 has to be charged. My take is the word is resolution should be passed. That means if it is there by default, even the default resolution has to be passed, which could be 0 to 100. Yeah, and on which there are a lot of judgment. So if no resolution is passed, 21 cannot be accepted by saying that because we did not pass a resolution lower than that, therefore maximum will apply. That reasoning would not apply because the word is as per resolution passed. So there has to be a resolution. So nothing is by default. And if there is no resolution, means no resolution. So you take 0 and charge 0 and then start applying the.
So that is the one thing where the resolution is not passed. In one society, everybody knows that the resolution has been passed, but they are not able to find it.
Okay, very good. If it is not able to pass, they can go through the old general body resolution, which they are supposed to maintain. Society is supposed to maintain a file, B file, and C file. A file is a permanent file where all the history has to be maintained, which means the incorporation certificate, all the AGMs which are affecting the people, not necessarily managing committee, but AGM has to be there. There would be cases of old stories where they have quoted that rule or section given. Now, if they cannot find it, they can come out and say, okay, we cannot find it, and we'll pass a new resolution. The idea is not to penalize, it is to regularize. And if it is passed to other people, they can pick out those cases and say, in 10 years ago, this was done, so it was an existing case. And then the lawyer will tell them how to correct it.
I want to add one more thing. Now, one more bylaws is going to come.
When it comes.
Right. Now, suppose if you have not adopted the bylaws and you are thinking of about in the bylaws 2014 or the 2024, which is shortly going to come, which is in the news. Now, if I adopt that bylaws, even if in that bylaws it says that the interest has to be charged up to 21%. So what happens to the previous resolution passed 35 years back that we can charge 21% to the defaulter? So in that bylaws, we have to make the changes again.
Sir, I have a different take. Bylaws are a rule which is the working arrangement within a society. It is not enforceable to outsiders. And neither can anybody else come and enforce the bylaw on the members of a society. In the past, before 2009 or 10, we used to have each society having its own bylaws. And it used to be difficult for the registrar to pass an order because the bylaws used to have wordings which were different. So they came out with something called a model bylaw. Model bylaw is recommendatory in nature that follows this template, follows this pattern, and then you get on with certain procedures. If a society decides that they want to adopt certain portions of it, or they want to adopt some more portions which are not there, they are free to do that. But for that, they go to the registrar looks at it and say, yes, model bylaw has got 175 bylaws. You want to bring in 176, 177, 178. Don't disturb the numbers that are in the model bylaw. You can add depending on the requirement of your society, so long as it is not against the general law or the prevailing law of the land. So if that is there, then registrar ko argue karke, justify karke, general body may you pass a resolution, it will become part of the bylaw as amendment or adoption of a bylaw for which a procedure has been defined. Merely by virtue of the fact that a 2018 or 2022 model bylaw is issued by the government does not make it binding automatically on you till you adopt it. That's why the wording in the act is adopted and approved by registrar. So you have to then adopt it in general body and get it approved by the registrar. Only then it becomes binding on the.
So if I am adopting the bylaws of 2014 or 2024, so I in the general AGM
can modify it.
Yeah, I have to modify that clause that henceforth the society will charge 21% interest to the defaulting members, which we used to charge here previously also.
You're free to do that.
We have to continue that.
You're free.
And there is one more bylaws also that needs to be adopted or modified. You are going. I will put that into the chat. Right now, I am just concentrating on the 21% interest. But there are judgments also of the High Court which comes to your help that you can charge 21%, but you cannot charge more than 21%. So I hope you all enjoyed, and Mohammed Afzal also came late. He was held up in the traffic, but keep in touch with us and till we meet.
Some closing remarks.
Well, I would suggest the managing committee that, technically speaking, they should not wait for a long time for the recovery. Once a 3 months bill is pending, they can issue the notice, follow the due process of law, and they can go in for recovery. And once the notice is issued, in most of the cases we have seen that the member comes forward and he tries to pay up whether in installments or in totality. So the managing committee should be proactive and they should follow the due process of law as far as recovery is concerned.
So stay tuned to our channel for more informative on legal topics and especially on cooperative housing society and consumer related issues. We will keep on making such videos. So stay tuned and keep safe till we meet again. Stay healthy and stay blessed and see you one more time in the next video. Till then, share this video with all of your friends and see you again. Thank you.